Am I audible to all? Please write in the chat box. Hello, Deepika, Mihira, Sanchet. We'll just wait for a couple of more minutes. Let other students come in and then we'll start the lecture. All right. So how are you all doing? How's your preparation going? We have very limited time now. Hardly you have 4 months. September, October, November. No, you only have 3 months now. So how's it going? Have your mocks? What what score you're getting in your mocks? मॉक स्कोर इम्प्रूव हो रहा है नहीं हो रहा क्या प्रॉब्लम्स हो रहे हैं डू शेयर इट विथ मी हाउ मेनी ऑफ यू यूजुअली गेट 70 plus in your mocks please raise your hand 70 plus in your mock and those of you who are not able to score 70-75 plus in your mock please work on your sectionals ठीक है लीगल में 25 तक स्कोर करना है आपको 25 plus RC and CR combined you should aim for 35 plus for quants try to get at least 7-8 एक पैसेज तो अच्छे से स्कोर करना ही है GK can be a bit tricky but getting 15 to 20 is not that difficult at least 15 तो आप एम करके चलो ही so overall 70 75 80 आपका स्कोर अभी होना चाहिए ठीक है and especially legal section see the three sections that you have the verbal part RC CR and legal make sure that you're getting somewhere around 60-65 in these three sections so ye aim karke chalo in case if you are having any issue if you are having any problem with these sections let me know I'll share my number with you all so अगर मॉक स्कोर को लेके प्रॉब्लम हो रहा है समझ में नहीं आ रहा कैसे इम्प्रूव कराना है क्या करना है फील फ्री टू कॉन्टैक्ट मी 3 महीने का टाइम है आई अंडरस्टैंड सम ऑफ यू विल बी राइटिंग योर मिड टर्म एग्जाम आल्सो स्कूल्स में अभी सितंबर में मिड टर्म्स होंगे अक्टूबर इज फुल ऑफ फेस्टिवल्स सो उस सिचुएशन में थोड़ा पहले से प्लान आउट करके करना है ऑलराइट yes Bhavya I'm sharing my number to all of you just a minute ठीक है so this is my number in case if you have any issues you can directly send me a message on WhatsApp now let's start with today's lecture so guys in this lecture we are going to cover important legal current affairs ठीक है so from the month of July so July में जो भी important legal current affairs हैं वो हम इस lecture में cover करेंगे and the first article that we have here is on creamy layer now can anyone tell me the concept of creamy layer it came from which Supreme Court judgment and what is this concept of creamy layer yes Sanchit it is for OBC and good very good Indra Swani case is the correct answer so I'll just explain everything देखो क्या हुआ ना कि initially as per our constitutional scheme reservation was provided only to SC and ST category people however the second backward commission which is popularly known as Mandal Commission it came out with its report in 88-89 and in during 1990s it was implemented after the implementation of OBC reservation a case was filed at the Supreme Court and it's a landmark case. The name is Indra Swani versus Union of India. In this case, the reservation which was given to OBC was challenged. Hence, this case is also known as Mandal Commission case. In this case, Supreme Court held that as per our constitutional scheme, it is permissible to give reservation to OBC. However, the ceiling of this reservation must not go beyond 50%, first thing. And second thing, only those OBCs who are part of non-creamy layer, only they can be given reservation. So for the first time, Supreme Court included economical criteria, है ना, income criteria for availing reservation. So Supreme Court ने कहा कि अगर एक फिक्स इनकम से ऊपर रहेगा ओबीसी में, फैमिली इनकम या लैंड रहेगा, in that case the person will not be eligible to avail reservation benefits of reservation, though the person belongs to OBC category. ठीक है? So this is the concept of creamy layer, right? Now why are we discussing it now? We are discussing it now because Supreme Court recently has observed that creamy layer criteria can also be can also be invoked in case of SC and ST reservation. ठीक है? So SC ST reservation may be creamy layer criteria which was previously not there, can now be adopted by the government. And what is the rationale of the government? What is the rationale of the Supreme Court? Why Supreme Court is allowing for sub-classification of scheduled caste and scheduled tribe? That is because of the fact that as per our constitution, that is as per Article 14 of the Constitution, which talks about equality before law and equal protection of law. So equal protection of law basically means that equals must be treated equally and unequals unequally. ठीक है? So equals को equally treat करने के लिए ये important है कि there has to be a classification, a reasonable classification which is based on intelligible differentia. ठीक है? Clear? Now just try to understand it through a very simple example. Let's say there are two people. Both of them are from ST category. One has studied throughout his life in some far-flung village of Jharkhand. The other one was the son of some IAS officer, and he has been thoroughly educated in Delhi. Now, though both of them, they belong to ST category, but do you think both of them can be placed similarly? They are alike, they are equal. The answer is no, though they belong to the same category. So Supreme Court ने भी यही कहा कि because the benefit of reservation has been extended only to certain class within SC and ST, hence it is important that a sub classification must be done within the category so that the benefit of reservation is given to those who actually deserve it. ठीक है? तो ये सब क्लासिफिकेशन परमिसिबल करके ये जजमेंट आया है. All right? So Supreme Court has observed that sub classification is permissible, first thing. Second thing, SC and ST is non-homogeneous in nature. That means every single person belonging to SC or ST is not alike, and on this basis, sub-classification is permissible. Article 341 was interpreted. The judgment spoke about substantive equality, right? Normative egalitarian equality जो है उसके बारे में इसने बात किया. Then creamy layer, first generation limitation, all these things were discussed. ठीक है? These are the important cases. The most important one is Indra Swani versus Union of India. Right? What are the legal concepts associated with this? So you have the definition of reservation, which is also known as positive discrimination, ठीक है, or affirmative action, and it falls under Article 14 and 16. Article 14 talks about equality before law and equal protection of law. You can see the definition of both the postulates of equality here. Then social, educational, and economic grounds. These are the grounds on which reservation can be given. ठीक है? तो social, educational, and economic grounds. Economic ground पे ही अभी recently EWS reservation जो है वो extend किया है government ने. Economically weaker section. By the way, those of you जिनका अभी you all will start filling your forms. Please make sure that your reservation certificate, those of you who intend to, avail the benefits of reservation, be it from SC, ST, OBC category or EWS category, please make sure that your certificates and everything is thoroughly, like you have it in your hand, right? EWS category में भी काफी अच्छे benefits मिल सकते हैं. So if you can get EWS category, try to get it done like in time. All right. Ananya, I don't know whether the class will be recorded or not. I guess so. Recording तो यहाँ चली रही है, तो आपको ये देखना होगा कि इसका एक्सेस आपको कहाँ पे मिल रहा है. ठीक है. Now, this social, educational, and economic ground, this is given in the constitution, and एक और बड़ी अच्छी चीज सुप्रीम कोर्ट ने कही कि पीरियोडिक रिव्यू होना चाहिए रिजर्वेशन बेनिफिट्स का. ऑलराइट. Next, slum rehabilitation scheme not to be seen as real estate development project. It's linked to right to life. So as you all know, Article 21 of the Constitution provides for right to life and personal liberty. And right to life includes right to livelihood. Okay? Right to livelihood. And this is not something which is new. Way back in 1980s, Supreme Court came out with this right. In Oliga Terrace case. Clear? Now, in this judgment, this case is in the context of slum rehabilitation in Borivali, Mumbai, under Maharashtra Slum Areas Act. All right. Now let's see what is right to livelihood and shelter. Read this part. So, right to life and personal liberty, as you all know, no person can be deprived of life or personal liberty except under a procedure established by law. This is what is given in Article 21 of the Constitution. Now, this procedure established by law, ये तो खैर अलग concept हो गया. Right to life के अंदर में right to livelihood is also there, right? And this livelihood includes right to shelter, right to work, and for fulfillment of the basic necessities of life. Okay, all right. So you can see here are a few of the landmark cases. Oliga Tellis versus BMC. This is one landmark case, very important. Advek, I'll handle your queries. I have given my number to all of you. If you have any particular query with respect to form filling, you can drop me a text. All right. Is it clear, Advek? Then you have Chameli Singh, Shanti Star Builders, right? So these are some important cases. All right. Next, exorbitant enrollment fees charged by State Bar Council is violation of right to professional dignity and equality. Supreme Court. Now, can anyone tell me what is the meaning of exorbitant? What is the meaning of this word exorbitant? Yes, Kavyani, absolutely correct. Extremely high. Okay? So, exorbitant enrollment fee. Now, see, as per Advocate Act, a state bar council is allowed only to charge 750 rupees as enrollment fee. However, most of the state bar councils were charging 10,000, 15,000, 20,000 as enrollment fees. Now, in this case, Supreme Court came heavily on these state bar council, and it held that if the statute only permits for 750 rupees as enrollment fee, then the state bar councils cannot charge more than that. Apart from that, the Supreme Court also held that by charging more money, in the form of enrollment fee, the bar councils are restricting people from vulnerable section, from the poorer section, to get into the profession. And this is not right practice. This is constitutionally not permissible. Why? Because it is creating economic barriers. Okay? Especially for those who are belonging, those who come from vulnerable section. Okay? So you can just check the key points here. Right to profession and dignity. This is part of Article 19(1)(g), freedom to practice any trade, profession, or business. Right. So freedom to practice legal profession also comes under it. Article 19(1)(g). Right. That is violated. Second thing is economic barrier is created because of these exorbitant fees. Then it also it has resulted in manifest arbitrariness. Why? Because the fee structure, which this fee structure prescribed by the state bar councils, they are not in line with Advocates Act, Section 24(1)(f) of Advocates Act, right? So, also Supreme Court held that the responsibility of the Bar Council is to promote inclusivity and to ensure diversity in the profession, right? तो ये सारे grounds पे Supreme Court ने इसको quash किया है, all right? Now here is Article 19(1)(g). I want all of you to read this. 19(1)(g). All right? So guarantees the right to practice any trade, profession, or business, ensuring freedom to choose and engage in lawful occupation. However, this is, as you all know, freedom given in Article 19. They are not absolute in nature, and reasonable restrictions can be imposed. Reasonable restrictions, however, reasonable restrictions which are only given in Article 19, subclause 6 can be imposed. Okay? So this part talks about reasonable restrictions. All right. Next, scope of Article 131 of Indian Constitution as interpreted by Supreme Court in West Bengal's case. ठीक है? So अभी क्या हुआ है West Bengal में? So as you all know, Central Bureau of Investigation (CBI), it comes under central government, right? And it is established through Delhi's Special Police Forces Act. Now CBI can investigate any case in any state, provided the state has given a general consent for such kind of investigation or special consent, right? Why this consent of the state is important? The consent of the state is important because law and order is a state subject. That is the reason why you see different states have different police. In Bihar, you have Bihar police. In UP, you have UP police. Why? Because law and order is a state subject. So when a central investigating agency has to investigate any case in a particular state, then it must take permission from that particular state. Clear? So this permission can be on a case-to-case basis, or it can be on, it can be a general mandate given by the state to the central government, right? Now, what happened is that the general consent given by the West Bengal government with respect to CBI investigation was revoked, and even after the revocation of such general consent, the CBI continued to investigate case in West Bengal. Hence, the West Bengal government filed a case against CBI and central government at Supreme Court under Article 131 of the Constitution. Now, Article 131 of the Constitution, it talks about original jurisdiction of the Supreme Court. So, Supreme Court under this article can take up any matter, any dispute between two states, or a state and a center, or a state or a UT, for example. Okay? So this is original jurisdiction of the Supreme Court. So West Bengal government had invoked Article 131, original jurisdiction of the Supreme Court. The central government, however, challenged the jurisdiction by stating that CBI is not central government, and hence Article 131 cannot be invoked, right? However, Supreme Court, expanded the scope of Article 131 and held that it can exercise original jurisdiction in this case. So I want you all to quickly go through this article. I hope it's audible to all of you. I hope it's visible to all of you. I have two questions here. Adhyan has asked me what is suo moto. So suo moto, Adhyan, it means by itself. है ना? तो Supreme Court has the power to take up matter by itself. कोई अलग से पिटिशन फाइल करने की जरूरत नहीं है. अगर सुप्रीम कोर्ट को रिक्वायर्ड लगा, जरूरत लगी, नेसेसिटी है, तो सुप्रीम कोर्ट कैन टेक अप अ मैटर बाय इटसेल्फ. दिस इज सू मोटर कॉग्निजेंस. Then I have another question Kavyaini, she is asking, is CBI a statutory body? Now, this is a very interesting question because the answer to this is no. CBI is not created through a statute. CBI is created through a government notification issued under Delhi Special Police Act. Okay? So technically, CBI is not a statutory body. Is it clear? Kavyani, is it clear to you? All right. So we can move on to the next article now. GM Mustard case, right? This again is a very interesting case. So GM mustard, as you all know, GM stands for genetically modified. So genetically modified mustard was prohibited. I mean, this is transgenic mustard hybrid, Dhara mustard 11, right? So Supreme Court has given a split verdict on approval of this transgenic mustard. All right. Now, what are the key points of coming out from this judgment? So, right to a safe and healthy environment. Now, given the fact that we don't know the long-term implication of these genetically modified crops, hence it cannot be concluded that they are safe and healthy for the environment, especially for human consumption. Then Supreme Court had invoked precautionary principle in this case, and it held that I mean, as per precautionary principle, it's better to take precaution than to and prevent a disaster than to experiment with a particular thing. So precautionary principle जो है वो disaster prevention के लिए है ना, तो उसको इन्वोक किया. Then disclosure of information, all kind of research associated with genetically modified crops should be disclosed to the public. Then it also spoke about comparative study and environmental decision makings. All right. Is it clear? Now let's move on to next topic. States' taxation powers must be protected from unconstitutional interference by Parliament. ठीक है, Supreme Court on fiscal federalism. Supreme Court has, now what is fiscal federalism? So fiscal means monetary, पैसे से related है, ठीक है. Federalism means division of power between center and state. So the state has certain areas where the state can tax, right? There are certain areas which are exclusively reserved for the center, right? Only center has the power to tax on those particular subjects. So in this case, Supreme Court held that the taxation power of the state must be protected from unconstitutional interference by the central government, by the parliament. Why? Because if states are deprived of their power to impose tax, then in a way the state will not be able to govern that particular area, है ना. उसके पास फंड ही नहीं रहेगा तो स्टेट कैसे गवर्न करेगा, एडमिनिस्टर कैसे करेगा, नहीं कर पाएगा. That is the reason why fiscal federalism is an important component of federalism. Without fiscal independence, the state cannot function that properly, right? So kindly read this part. The court highlighted that taxation is a crucial source of revenue for states, enabling them to perform core constitutional functions independently. ठीक है? Then states taxing power. ये सारा फटाफट एक बार पढ़ लो. This I have explained just now. So quickly go through these important points. I hope it is clearly visible to all of you. All of you done with it? All right, fantastic. So let's move on to next topic. Confession before police cannot be included in charge sheet. Supreme Court has held this. Now, what is confession? Let us first try to understand that. So, confession, or just a minute, yes, confession का मतलब क्या होता है? Acceptance of guilt, absolutely correct. So when the accused, he is aware about something which is very personal in nature with respect to the crime, and when he accept the guilt, when he shares that particular those facts with the police, with anyone else, that is confession. Now, as per our criminal justice system, confession in front of a police officer, confession in custody or to a police officer is not admissible in law. ठीक है? Clear? क्यों? क्योंकि we all know इंडिया में पुलिस किस तरह से काम करती है. If confession in custody or in front of a police officer is allowed, then probably all the cases in the country will be resolved within few days. वो थर्ड डिग्री का यूज करके कुछ भी किसी से भी कन्फेस करा सकती है, right? So that is the reason, as per law, confession in front of a police officer or in custody is not admissible as a court of as an evidence. All right. Now, in this context, Supreme Court has held that if confession before police is not admissible in a court of law, then it must not be included in the charge sheet as well. Now, what is a charge sheet? So, charge sheet is the final document which is filed by the police after completion of the investigation. Where is it filed? It is filed in front of in a court of law. Okay? Clear? Now, here are the legal concepts with respect to confession. So, I have already explained section 25, which says that confession made to a police officer is not admissible. As per section 27 of Indian Evidence Act, though confession is not admissible, custodial confession is not admissible. However, any fact, any information that leads to the discovery of a particular fact can be proved. For example, A confessed to the police officer that he had killed B, and after killing B, he, the murder weapon, he had thrown the murder weapon at a particular place. Now, police officer acting on this information, discovers the murder weapon. In this case, a pistol. So, though the fact which involves his confession, that is, he committed the crime, is not admissible in the court of law, but the fact that on the basis of the information given by the accused, a pistol was recovered from that particular place is admissible in court of law. Okay? I hope it's clear now. Okay, so I hope the distinction between section 25 and 27 is clear now. Now, what is the meaning of custody? So, as per landmark judgments of the Supreme Court, custody includes not just formal arrest but also situations where the accused is under effective control of the police. So, here the court has observed that the constructive and effective control is what matters. तो हाथ में हथकड़ियां रहे ये जरूरी नहीं है. अगर effective control है, then even that includes that also falls within the ambit of custody. All right. चलो आगे बढ़ते हैं. State can't alter schedule caste list published under Article 341. So see, as per Article 341 of the Constitution, the president only is entitled to, alter the list or to include any caste in scheduled caste category. Okay? The state government has no power, has no, role in this. Clear? So Supreme Court has reiterated this fact, and this was in the context of, inclusion of Tanti Tantwa community of Bihar in the SC list. Clear? Now, here are the legal concepts associated with Article 341. Read this part. As you can see, president only can specify caste and tribes to be considered as SC or ST. The governor has no power, no such power. ठीक है? I hope it's clear. Let's move on. If right to speedy trial is violated, constitutional courts can grant bail despite statutory restrictions. All right. Now, what is the meaning of this? So, right to speedy trial, it is an integral part of Article 21 of the Constitution. Speedy trial क्यों? क्योंकि आप किसी को अरेस्ट करके आपने जेल में बंद कर रखा है, and that person is languishing behind the bar from like 5 years. The maximum punishment is 7 years. अब इस तरह से अगर आप किसी को जेल में बंद करके रखे हो, and tomorrow the court comes up with this verdict that the person is not guilty, then who is going to pay for the punishment that innocent person had undergone? ठीक है, that is the reason concept of bail and concept of right to speedy trial is very important, because it intends to protect the personal liberty of individuals. All right, so ये हमेशा ध्यान रखोगे. Right to speedy trial, there have been so many landmark cases. Here you can see Husainera Khatun, AR Antulya, KA Nazib, all these are very important cases. ठीक है? And this right to speedy trial is available even when a person is charged under UAPA or Money Laundering Act. Ab UAPA and money laundering are these two are draconian acts. Why? Because bail is not allowed in these in these cases. However, Supreme Court has held that right to speedy trial is still applicable in case of UAPA and money laundering cases. ठीक है? Quickly go through this part. So हुसैनरा खातून में भी PIL था, उसने PIL नहीं, a letter was sent and उसके बेसिस पे सुप्रीम कोर्ट ने कॉग्निजेंस लिया था. PIL अगर देखा जाए तो MC मेहता और ये सब जो केसेस है ना, कामगार मजदूर कामगार, ये सब वाले केसेस में PIL स्टार्ट हुआ था. ऑल राइट. Harshit, yes, bail can be granted even under new criminal law. Next, Collegium recommends appointment of Justice N. Koteswar Singh and Justice R. Madhavan as Supreme Court judges. So, N. Koteswar Singh from and Justice R. Madhavan. N. Koteswar Singh was the current Chief Justice of Jammu and Kashmir High Court, and R. Madhavan was the acting Chief Justice of Madras High Court. ठीक है? So collegium, as you all know, it came. Kavyani, just a minute. Yes. Kavyani, please let me know once you are done with this. All right, fantastic. So these three are important cases with respect to appointment of judges at High Court and Supreme Court. First judge's case, in this case, Supreme Court held that President will have the final word when it comes to appointment of judges. In second judge's case, however, Supreme Court held that judiciary has primacy in case of judicial appointments. Why? Because government is the biggest litigant, and if the government has the sole authority, has the final authority to appoint judges, then in that case, somehow independence of judiciary can be affected, and which would violate the basic structure of the constitution. So in this context, Supreme Court came up with the institution of collegium. Collegium comprises of the Chief Justice and four other senior judges of the Supreme Court, and they recommend names to the President for appointment at High Court and Supreme Court. ठीक है. Third judge's case was a presidential reference under Article 143 of the Constitution, and through this presidential reference, the Supreme Court again reiterated the collegium system. Thereafter, way back in 2014, the government came up with NJAC Act, National Judicial Appointments Commission Act, to replace the collegium system. However, this NJAC was declared unconstitutional by the Supreme Court in 2016. So currently, we have collegium system. All right. Soumya, President had the final say. As per Article 124 of the Constitution, in first judge's case, Supreme Court held that the President will have the final say. However, after the collegium system, if the collegium has recommended a name twice, then the President has no other option but to appoint that person as a judge. All right. Soumya, is it clear to you? Chalo, presumption of non-application of mind if bail order does not furnish reason. Who's going to tell me the meaning of the word bail? What do you mean by bail? Kindly write your answers in the chat box. Yes, Kavyani, bail is an order of the court through which a person in custody and under trial in custody is released temporarily. Okay, so release of an under trial from custody, this is bail order. Now, if the bail order does not furnish reason, then the Supreme Court has said that it would presume that there is non-application of judicial mind in such cases. Now, why it is important? It is important because Supreme Court has time and again held that the orders must have reasons. Why? Because reasoned order are part of principles of natural justice. If an order does not have reason, then it cannot be challenged properly in a court of law. Just saying that a person is guilty and not guilty without proper justification violates the right of that individual. Okay? So an order should always be a reasoned order. Why? Because reasoned order are part of principles of natural justice. It is based on fair hearing. It ensures transparency, accountability, and fair hearing. Here are a few of the cases. All right, next. Hindu Marriage Act. Divorce petition can be filed if spouse ignores restitution of conjugal rights degree for over 1 year. Now, what is restitution of conjugal right? What do you mean by conjugal right? First, tell me that. What is the meaning of the word conjugal? Guys, anyone here, please write it in the chat box if you know the meaning of the word conjugal. Marital rights. Yes, absolutely correct, Kavyani. So, restitution of conjugal rights basically means, it is an order which is passed by a family court in cases where the other spouse is not willing to stay together or is living separately. Okay? So, without any justifiable ground, if the spouse is, living separately, then the other person can file a case against against the spouse, asking for restitution of marital rights, restitution of conjugal rights. All right, clear? So in this case, Supreme Court has held that if the spouse has ignored restitution of conjugal rights degree for over a year, then divorce petition can be filed. Now, as per Hindu Marriage Act, divorce is filed under section 13, and here are some of the grounds. Okay? Here are some of the grounds for divorce under section 13 of the act. So you have adultery as a ground, cruelty, desertion, conversion to another religion, mental disorder, leprosy, vernal disease, renunciation of the world, presumption of death. Okay? These are some of the grounds given in section 13. Now, restitution of conjugal rights comes from section 9 of Hindu Marriage Act. Kindly read this. Yes, Mihira, you are absolutely correct. Acha, why you guys don't attend, the weekly current affairs lecture? Every week we have lectures on Friday, on Wednesday, as well as on Sunday, between 6:30 to 8:30 on Wednesday and 4 to 6 on Sunday. And these lectures are very important from the point of view of upcoming CLAT examination. Okay, so kindly make sure that you guys that you are present in the lecture. Next, people don't purchase high-end luxury cars to suffer discomfort. Now, again, this was a consumer case. Here in this case, a person bought Mercedes Benz, and the vehicle that he got, it had certain flaws, right? उसका जो airbag था वो timely नहीं खुला था. Non-deployment of airbag during a collision that happened, and injuries were caused to the passengers, right? So in this case, he filed a case, at a consumer forum, and Supreme Court held that luxury cars, people buy luxury cars for their safety features, for the comfort, right? And in case if these things are not delivered, then the rights of the consumer has been affected. Why? Because it can amount to deficiency in services. So here are two things that you need to understand. What are the rights of the consumer? So under Consumer Protection Act 1986, consumers are entitled to various rights such as right to safety, right to information, right to choose, right to be heard, right? So these are important rights that the consumer have. Then they also have, in case of deficiency in services, a consumer can file a case um, against the company. In case of unfair trade practices, again the consumer can file a case. All right. Next, Supreme Court. Divorced Muslim women can seek maintenance under Section 125 CRPC alongside 1986 Act. Okay, 1986 is the it's a special act which is applicable only to Muslims, right? So the Muslim Women Protection of Rights on Divorce Act 1986. So maintenance, as you all know, in case of divorce or where the wife is living separately, then she can get some amount from the husband for sustaining herself. So this is known as maintenance. It can be a monthly alimony or it can be a permanent alimony. Monthly alimony is the monthly amount that the husband is legally bound to give to the wife, and permanent alimony is one lump sum alimony given by the husband. Clear? I hope it's clear. So here in this case, Supreme Court held that the Muslim women can seek maintenance under both the act. One is a neutral act, which is Section 125 of CRPC, and the other one is Muslim Women Protection of Rights on Divorce Act. All right, I hope it is clear now. Death by single stab can be considered murder if ingredients of Section 300 IPC are fulfilled. All right. So this again is a very interesting case. In this case, Supreme Court held that though there was just one single stab, however, if it has caused the death, and if the intention was to cause death, then the person can still be held liable for murder. All right, clear? Now, murder and culpable homicide, you all must have read it in your criminal law lecture. So, under IPC, murder was defined under section 300 and culpable homicide under section 299. काफी इंटरेस्टिंग है इसका डेफिनेशन, इससे काफी सारे केसेस जो हैं वो आ रखे हैं. आई एम प्रीटी श्योर दैट यू मस्ट हैव सीन फ्यू पैसेजेस इन योर मॉक एंड इवन इन योर कोर्सवेयर शीट्स पे भी आपको मिली होगी, राइट? सो ये थोड़ा आप ध्यान रखोगे. सो एंजल, आई थिंक सेक्शन मर्डर इज डिफाइंड अंडर सेक्शन 100 ऑफ बीएनएस, भारतीय न्याय संहिता. एक बार आप चेक कर लेना. All right. So section 100 defines culpable homicide in BNS. So here, in case of culpable homicide and murder, intention plays a very important role. Mens rea जो है, intention and knowledge, and वो figure out करना थोड़ा important हो जाता है. Now, what are the legal concepts that you have to learn here? So read this paragraph. What is culpable homicide? So whoever causes death with the intention to cause death, or with the intention to cause such bodily injury which can cause death, or which is likely to, which the accused knew can cause death, है ना? It can amount to culpable homicide. Clear? मर्डर जो है वो थोड़ा अलग है. मर्डर में क्या है कि जो मेंस रिया है, डिग्री ऑफ मेंस रिया इज ऑन अ हायर साइड. So all murders are culpable homicide, but all culpable homicides are not murder. Clear? I hope it is clear to all of you. बहुत ज्यादा डिटेल में मैं नहीं जा रहा because this concept is a bit lengthy. It requires minimum 40-50 minutes of lecture. So अभी I'm not getting into it. Next, Indian husbands must financially empower their wives who do not have independent source of income. All right, just a minute. By the way, you all have LR sprint this weekend. How many of you will be participating in it? LR sprint, upcoming LR sprint. Please raise your hand. Yes, it's a very important event. So you have close to 200-300 questions, right? अगर आप अच्छे से LR sprint participate कर लोगे, so those of you who are having any issue, in logical reasoning section, trust me, आपके काफी सारे issues resolve हो जाएंगे. So please make sure that you are attending all these lectures. Alright, lectures attend करना बहुत जरूरी है. आप उसको skip नहीं करोगे. LR sprint. So Harshit and Sanchit, I'm pretty sure that you must have received some information from your EAs from the center. Inquire about this at your center level. You guys are from which center, by the way, Harshit and Sanchit? ठीक है. Just have a word with the center and they'll let you know कि वहाँ center level पे कब LR sprint हो रहा है. But it's a very important event and logical reasoning section जो है वो आपका काफी हद तक clear हो जाएगा. Also, very soon you guys are gonna have your monthly magazine, half yearly magazine. So half yearly magazine that we're gonna provide you, it has most important news articles from past 6 months. तो जीके जो है ना वो आपका 80-90% हाफ ईयरली मैगजीन से कवर हो जाएगा अभी तक का. So in case, let's say, if you may have missed the current affair articles from January, Feb, March onwards, या जो भी months का miss हुआ होगा, if you are thorough with the half yearly magazine, your GK preparation will be on a next level. ठीक है, तो हाफ ईयरली मैगजीन आएगा, तुरंत उसको फटाफट कंप्लीट करना. Next, Indian husbands must financially empower their wives who do not have independent source of income. Supreme Court. So in this case, Supreme Court has held that the husbands, they are legally bound to support the wife, and this is not related to maintenance. Maintenance is allowed only when the wife is living separately. This case relates to such situation where the husband and wife both are living together. However, even in such situation, husband is legally bound to empower their wives, है ना, by giving them financial assistance. So most of the homemakers, they do not have any independent source of income, but that does not mean that they do not they are not legally entitled to get money from the husband. ठीक है, तो इस केस में सुप्रीम कोर्ट ने ये कहा था. Finally, the last lecture that we have, the last topic that we have here is disabling humor. So this paraging persons with disability must be distinguished from disability humor. So in this case, Supreme Court came heavily on the entertainment industry, and it held that disabling humor should be criticized at the highest level. Why? Because it hurts the sentiments of the disabled people, right? So Divyangs, उनको रेफर करने का तरीका या उनको जब शो भी कर रहे हो, तो in that case the media creators, they should be very sensitive while representing Divyangs. ठीक है, so they must not be called as cripple or spastic. अब अंधे को अंधा कहोगे तो मतलब this is very wrong, right? This is what I'm trying to tell you through this judgment. So Supreme Court came heavily on such kind of practices, especially in the media industry, and it held that media creators should be very sensitive when it comes to displaying the yes, when it comes to when it comes to showing disables. ठीक है, all right. So inclusive, it spoke about inclusive decision making, training and sensitization of people in the media sector. Then certain guidelines were also given by the Supreme Court. All right. So these are the important judgments from the month of July. All right. Very soon we are going to have a similar kind of lecture, which will be on important Supreme Court judgments from the month of August. So in case if you have any doubt, if you have any question, you can ask me. You can write it in the chat box. In case if you have any question, even with respect to your preparation, overall preparation, कोई भी दिक्कत हो, कुछ भी हो, you can let me know. All right. So I'm just writing my number again here. Yes, in case if you guys have any issue, अगर mock score नहीं बढ़ रहा, प्रॉब्लम हो रही है किसी एक पर्टिकुलर सेक्शन में, स्टडी मटेरियल को लेके कोई भी इशू, कुछ भी है, एनीथिंग, है ना, you have my number, you can directly text me and then we can I'll try my best to resolve your issues. All right, चलो, all the best guys. 3 महीने का टाइम है, प्लीज वर्क हार्ड एंड मेक श्योर कि आपका जो वो ड्रीम कॉलेज है, जो NLU है, वो उस ड्रीम कॉलेज में आप पहुंच रहे हो. ठीक है, टाइम है अभी भी. I understand that you may have to manage your preparation along with your midterm exams, your school studies, but trust me, it's totally worth it. So Deepika, 72 is a good score, but I still see a lot of scope. You should try to increase it to 85, है ना. दीपिका, ये अभी 85 तक जाएगा आपका. आप थोड़ा और मेहनत करो. इन केस इफ यू हैव इशू इन अ पर्टिकुलर सेक्शन, यू लेट मी नो. ठीक है, सो आई सी सम स्कोप ऑफ इम्प्रूवमेंट. आप इसको 75 72 से 85 तक लेके ट्राई करो इसको एक्सटेंड करने का. एंड 1 महीने के अंदर ये पॉसिबल है, अगर आप थोड़ा स्ट्रेटेजिकली इस पे काम करो तो. All right. चलो, thank you so much guys. Thank you. Bye. Good night.